at the end of the program. Apparently, a little technical difficulties there. My apologies.
All right, so this is what we're going to talk about today. Business entity selection, doing business with a business partner, doing business as a franchise or an independent business, site selection issues, if you're going to have your business located outside your home or even in your home, some general contract related issues, and we'll quickly touch on some intellectual property issues. Okay, next slide, please. So this presentation is, in general, a mile wide and an inch deep. We talk about a lot of different topics. We don't get into a great depth of any of those topics because I'm just not sure of the background and the knowledge of the people that are in the audience. So it's relatively general. Okay, we can go to the next slide. All right, so business entity selection. These are generally the options that you have. You can do business as a sole proprietorship, business as a general partnership, a limited partnership, a limited liability company, or a corporation. So doing business as a sole proprietorship, you don't create an entity. There is no entity separate and apart from you, and you are the business. So to create a sole proprietorship, you do not file any paperwork with the Secretary of State. You just start selling your stuff. And by you selling your stuff and someone buying your stuff, you've legally created a sole proprietorship. If you go create a bank account, the bank account will be in your name. Even if you have a doing business as name or a trade name, you're still doing business under your own name. Another option you have is a general partnership. And this is basically the same thing as a sole proprietorship, except you have someone else helping you. So you have a general partnership. It's two or more people going into business and receiving income from that. The downside of a sole proprietorship and a general partnership or a partnership is that you are personally liable for everything that you do. And in a partnership, you're personally liable for everything that your partner does. So an example would be you're selling, baked goods. You go to, various farmers markets or street fairs and you sell your stuff. And ultimately, someone gets sick on an undisclosed allergen. And ultimately, they file a lawsuit against you. They'd be filing a lawsuit against you individually. And all your assets that you own individually and or through your business are up for collection. So I have never helped someone purposely create a sole proprietorship or a general partnership in the 24 years I've been practicing law. Generally, those just happen. You and a friend of yours say, hey, you like to cook, I like to sell, or we both like to cook or bake. And why don't we just start, get a booth at a local street fair and see what happens. And that's generally how things go with a sole proprietorship or a partnership. So one of the main deterrents of creating a sole proprietorship or a partnership is that unlimited personal liability. A very flexible organization to operate, but ultimately, I believe that the personal liability outweighs just about any other benefit that there may be for a sole proprietorship or a partnership. Then we have a limited partnership, which again, because of the advent of limited liability companies in the 1990s, in my opinion, put the limited partnership the way of the dinosaur. They're not needed anymore. They were the alternative to a corporation and the alternative to a general partnership when there were, pre-1990. But now that you have a limited liability company, unbelievably flexible organization, basically freedom of contract. You can operate your limited liability company and make it feel like a corporation, make it feel like a limited partnership, make it feel like a general partnership. It's a very flexible. Your limited liability company is a very flexible entity, and then you have your corporation, which has been around for hundreds of years, and your little corporation that you create is no different than General Motors. You have shareholders, you have board of directors, you have officers, all making different decisions. You can so it's a little bit unwieldy when you're there's only one or two shareholders when you create this corporation because you have these divisions of decision making. But ultimately, you can create execute a close corporation agreement to make it a little bit more simpler to operate. So if I create 20 companies, probably 18 or 19 of those are limited liability companies, and the others are corporations. And there's usually some specific reason why it's a corporation, whether it's a particular tax benefit, Maybe it's a funding mechanism that's requiring you to be a corporation. Or maybe, you're going to be a franchise and the franchise requires you to be a corporation to become a franchisee. So there's usually some reason why you become a corporation. But then, stepping back, limited liability companies, the owners of those companies, they're considered to be members. Corporations, the owners are considered to be shareholders. So just a different terminology. The with the operation and management of a limited liability company, it can be amongst all the members. The members can elect a manager to run the company, more similar to a president. So it's a very flexible, organization. The rules were just updated a couple of years ago for limited liability companies, and try to make it a little bit more streamlined, get the laws a little bit more similar to what other states have also passed. We're a corporation, like I mentioned, you have shareholders making the big decisions, the board of directors making the 10,000-foot decisions, then you have officers, the president, secretary, treasurer, vice president making the day-to-day decisions for that entity. But the nice thing about a limited liability company or corporation, as opposed to a sole proprietorship and a partnership, you do actually file paperwork with the Ohio Secretary of State to create your limited liability company or a corporation. And it's a separate entity. The limited liability company or corporation, they're separate entities, distinct and apart from the owner. So if the corporate entity does something that creates liability, again, the same example, someone getting sick on a cookie that you made from a street fair, your corporate entity is responsible for that lawsuit or that claim, and not you individually. So when you create that limited liability company or corporation, you're insulating yourself personally from that personal liability, unless you do something illegal, fraudulent. You don't respect the corporate formalities of your entity by basically paying for personal items out of your corporate checkbook, and that could be, you put an addition on your house. That's a business expense. I go on vacation. No business, discuss, no business purpose, but I'm going to have my company, pay for it. Those are items that are not business related, and you're not respecting the formalities where to pay for those personal expenses, you need to get the money out of your corporate entity, out of your company checking account. The money has to hit your personal checking account, and then you can use it for personal reasons. Taxes. I don't get involved in taxes or taxation. I know a little bit, generally refer clients to their accountant to determine how the corporate entity should be taxed. You basically, for a limited liability company, there's no separate taxation from the IRS for a limited liability company. The tax is based on how many owners you have. So if you have one owner of a limited liability company, then by default, you're treated as a sole proprietorship. If you have two or more members of a limited liability company, then by default, you're taxed as a general partnership. But you can make a sub-S tax election for your limited liability company to be taxed more like a corporation. And then for a corporation, by default, you're taxed as a C corporation, which means your corporate entity itself pays tax when you earn your money. And then also your corporate entity pays tax when you issue a dividend. So there's double taxation on those distributions or those dividends with a C corporation. But a corporation can also make the sub-S tax election. And then there's no corporate taxation. So whether you're taxed as a sole proprietorship, general partnership, or you've made the sub-S tax election, your corporate entity itself does not pay tax, and all those taxes flow through to your personal tax return. So you don't have that separate corporate tax that you are paying. I think we're good with that. You can move to the next slide, please. And then doing business with a partner. So I am not anti-partner, but I am I do advise clients to be very careful about ultimately having a business partner. Business partnerships are no different than marriages. I see quite a few business partnerships that don't go well, even from almost the very beginning, before the business is even open and operating. So no different than a marriage. For your business partnership to be successful, you need to have, expectations that everyone understands, and also that communication. People need to, everyone inside the company needs to understand, what is going on, what's expected, how much time's expected of me, how much is the other person working. Um, and then what happens when there's, changes in life situations? It's not uncommon for, two younger people who maybe aren't married, maybe even still in school, start up a business, and then it becomes successful. And then, one says, hey, well, I want to do what I actually went to college for. And I want to, do something different here. But then the other one is stuck doing all the work. And instead of being a 50-50 time spending, operating the business, now it's maybe 80-20, but the ownership is 50-50 splitting profits. And so, you can get some hard feelings there. So you need to have these conversations, and they need to be upfront, about how much time is expected between the owners. Just because someone works hard, just because someone's a good employee, doesn't mean that equals ownership. And generally, I'll have clients that'll say employees, have expressed an interest in becoming an owner. And I'm like, okay, well, what about when things go bad? COVID happens. You don't have the revenue coming in, but you still have all your expenses. So the owners have to come up with $20,000 to meet payroll or to meet, rent or other expenses. If, they're a 25% owner, are they willing to put in $5,000 of their own money into your business to keep things afloat? And if the answer to that question is no, then they're not ownership material. You can, have a contract with that employee and share, profits with them based on performance or something to that effect. But as an owner, you get the good, the bad, and the ugly. As an owner, you just don't get profit distributions. If you can't make payroll, then you're not getting a paycheck that month. And heaven forbid, you need to you're short money and you have to come up with money out of your own pocket to put back in the company. So you really have to be careful once you make someone a business partner, because it's very difficult to remove them. You can have language in the agreement that upon certain factors being met, you can redeem that person. But ultimately, just really be careful. As soon as you utter, I'd like to make you a business partner, and then you talk to your attorney, and the attorney goes, well, maybe not. What about this? And then you're like, well, you're right. Maybe I don't need to make him an owner. But as soon as you, ring that bell, obviously it can't get wrong, and that person's going to be a little upset that, what they were hoping would happen is not happening anymore. So really be careful about making someone a business partner. Not saying I'm anti-partner, but really vet that person and make sure it's in the long-term interests of you and the company for that person to be an owner. And then I have this financial considerations and equity versus loan, because I had a client keep coming up to me and goes, I have an investor, I have an investor, I have a business partner. And I'm like, okay, well, how much ownership did you give them in return for that person giving you money? And they're like, well, nothing. I'm still 100% owner. I'm like, well, then how are they giving you money? They're like, well, they're investing in my company. I'm like, do you have to pay them back? They're like, oh, yeah. I'm like, well, they're a bank. They're a lender. They're giving you a loan. You have to pay back no matter how well your business succeeds, which is different than an equity investment in your company, which is like Shark Tank. They're not getting that money back if your business fails. So two very different considerations, whether that investment is ultimately going to be in equity and in ownership in the company, and if the company fails, you don't have to pay it back, or do you have to pay it back no matter whether the company makes it or not? And if you get money from friends and family to help start your business, I think that's even more important to have that documented than a loan from some third person you don't know. Because with these friends and family, they're like, oh, I just want to see you do well. And then next thing you know, you're going on vacations, you're buying new cars, you're always in new clothes. They're like, I thought I gave you the money for your company. Like, well, I got to look good. I can't look like a bum out on the street. I got to look like I made it. And you're like, you're dressing nicer than I am on my money. And so there needs to be a very clear understanding of whether you want to get repaid. How, if you're the bank, you're the private lender, do you want to get repaid? How do you want to when do you want to get repaid? How can the money be used? Are you going to put restrictions on how this money can be used? As opposed to just saying, hey, here's 10 grand, good luck with your business venture. And if you're going to be upset that they're not spending it the way you wanted, then you better put some controls on how they can spend that money. Because you don't want to ruin a friendship, or is this someone that you're going to be seeing regularly at family events and things like that? So you just want to make sure everyone's on the same page with investments that are going to be made. Okay, you can go to the next slide. franchising or independent. There's benefits of both being a franchise business and I have clients that are both. Um, but if franchise and all franchises are created equally. Some franchises have very little support for their franchisees. Some are brand new franchises that that are still trying to figure out how this franchising model works. And then there's other franchises that have been have been in business for a very long time, and they're like operating a well-run machine. And so you just want to make sure you do a lot of due diligence to determine if you want to become a franchise or not, knowing that at the minimum 7 to 15% of every dollar you earn goes right back to the franchisee. And is it going to be worth it? As opposed to just starting up your own independent business. And you're going to have some struggles. You're going to have some U-turns. This didn't work out or that didn't work out. Where in a franchise, the thought is they've worked out all the bugs of this business, and you should be ready to go. And you have a very knowledge, and the franchisor has a very knowledgeable staff to answer your questions and point you in the right direction. So I'm not anti-franchise, but you just have to know what you're getting into. It's going to be 50, 60, 70, 80 page franchise agreement that you're going to sign. There's generally no modifications that can be made to your relationship with the franchisor. So you have to, understand what you're getting into and be comfortable with that. In general, if you're a creative person, you always like to tinker. You always think there's a better way to get something done. You always like to try to improve things, then a franchise is not for you. You have to be satisfied with the model that the franchisor has created, and basically you just follow their plan book page by page. And if that's not something that you're comfortable with, then don't even go the route of a franchise, because you're not going to be happy. You're always going to be like, this is stupid. These people don't know what they're doing. Why couldn't I look? This is simple. Why didn't they think of this change? Where you can make those suggestions to your franchisor, but by no means do they have to accept those. And so, it's really, what kind of business background do you have? What kind of support do you have? How much time are you going to be investing into this business this business operation to know if it makes sense to go the route of a franchise or an independent business? So the one thing I will say is when I have two businesses start up, two brand new businesses, one's a franchise and one's an independent business, the franchisor is going to generally require some sort of upfront investment prior to you even being open for marketing purposes, because the franchisor wants you to hit the ground running and already have a little bit of a buzz about your business before you're even open, or coming soon and all these other things. We're an independent business. I've never seen an independent business owner put any type of serious marketing dollars to, pre-opening. It's usually I'll increase my marketing for an independent business owner. It's usually I'll increase my marketing as my sales allow. Where the franchisor is just requiring that these investments be made because the franchisor knows how important it is to have that that business already getting ready to be generated on the day you open. And plus, they obviously want to get the increased sales because that's how they get their franchise fee. But I will say that's probably one of the biggest differences I see is the amount of marketing dollars spent prior to opening between a franchise and an independent business. So, and there's a franchise that's a franchise matchmaker. That'll help you. That'll put you through a personality test, a business acumen test to determine which types of franchises would be appropriate for your, business level, how much time you're going to be putting into the business, tolerance for risks, and all these other things. So there's just a lot of options with franchises, and more options than you can even imagine that can be franchises, all the way from McDonald's, to picking up dog poop in someone's yard, or going around cleaning people's garbage cans. So there's just an unbelievable array of franchises. So, okay, next slide, please. All right, site selection. So, this is, where are you going to operate your business? Are you going to rent a location? Are you going to buy a building? Are you going to operate your business out of your home? It's knowing that the zoning and the location where you want to operate your business is going to accommodate your business and possibly how you want to expand your business in the future. You just have to contact the local building department, give them your address, and they will let you know if your proposed business will be acceptable in that location. Um, my experience has been the people that are work in the building departments, they're generally very helpful. They'd rather help you out on the front end, deal with an issue rather than you become an enforcement issue. So you do want to make sure that your business is zoned properly. And just because the prior business that was in your location was operating doesn't mean the property is zoned for that. They could have gotten some sort of um, waiver to be able to operate in that location, and that waiver would only apply to their business. So it's always just a really quick phone call, or stop in to the building department and say, hey, if I want to run a business at this address, will that be permitted? And they will let you know. Liquor licenses, different animal. Each community has an allotment of certain types of the different types of liquor licenses, and so you also want to make sure you have that addressed also, if you're looking to sell alcohol on premises or as a carryout. Okay, next slide, please. And then lease issues. There's no standard lease. If someone says, oh, this is the Cleveland lease or this is the Akron lease or whatever, there's no such thing. Every lease is different. Every landlord creates a different lease, but these topics will be in every commercial lease that you sign. And so the biggest, so I'll just quickly go through these. Your term and renewals. How long is your initial term going to be? And are there any type of automatic renewals that are permitted? And then, my experience has been, the term of the lease and the rent charged are usually inverse to each other. So the shorter the term, the higher the rent. The longer the term, the lower the rent, because the landlord doesn't have to worry about having to release the property in the future. But as a new business owner, you really don't want to sign a 10-year lease because you don't know if you're going to be successful or not, or if you have to grow or move. So usually for new business owners, my suggestion is the shortest lease possible, even if it's a higher rent, because you don't want to be in a 5-year lease in real. Like, say you're a baker and you've been cooking out of your home, you've been baking out of your home as a cottage food bakery, and then you want to go back out and you want to rent a space, and you're like, okay, a 5-year lease, my business will make it. You're like, yeah, your business is successful, but will it increase in volume enough to warrant covering all those lease expenses? And you're like, wow, this experiment didn't work. I gave it 2 years. I just need to go back to my home because I don't need all these extra expenses. But if you signed a 5-year lease, you're stuck for another 3 years. So ultimately, my suggestion is generally you're better off paying a little bit more in rent those first couple years, with having the flexibility to move if you need to. Monthly rent, percentage rent, and CAM. Your monthly rent, that's going to be, every month you pay $1,500 in rent no matter what happens. Percentage rent is if you're in like a Crocker Park or a Legacy Village or something like that, and you're a retail space, many times those landlords will require the payment of a percentage rent, which is literally, it's just a percentage of your sales that you pay to the landlord in addition to your monthly rent. And the thought behind that is the landlord does things and incurs expenses to ultimately draw patrons to the mall. Could be Santa Claus, concerts, things like that. And so you want to read your lease carefully to see if there is a percentage rent component. And then CAM is your common area maintenance. And that is the landlord's expenses for the areas that are in common to all tenants. All tenants can use, but no tenants have the exclusive right to use. Parking lot, lawn, snow removal. Maybe it's a common bathroom in a hallway, hallways, elevators, things like that. And then typically the landlord will request reimbursement for those expenses based on your percentage, the number of square feet that you're renting in relation to the entire building. So it's your percentage of square feet that you're renting. So if you rent, the premises that you're renting is 3% of the total square footage, then you would pay 3% of the landlord's common area maintenance. Triple net lease, that is the tenant reimbursing the landlord for the landlord's costs, and such as the landlord's real estate taxes, the landlord's insurance premiums to insure the building against fire or damage, and also capital improvements that the landlord makes. And the landlord would ultimately, just like the common area maintenance, you would get your percentage bill to reimburse the landlord for those expenses. And in my opinion, you need to be in a pretty nice space that you're leasing to be paying, reimbursing the landlord their property taxes and their insurance premiums and their capital improvements. So you just want to make sure that you understand, the location that you're leasing, because you look at it and go, hey, my rent's $1,500 a month, but you're paying percentage rent, CAM, and your share of the triple net. And you're like, wow, that first bill is $3,500. I wasn't expecting that, or whatever it may be. So you just want to understand your full, monthly payment that you're going to be making to the landlord, in addition to utility payments. And then landlord responsibilities, tenant responsibilities go hand in hand. If something breaks in your space, someone's got to fix it. And the lease will say whether that's the landlord or the tenant. And probably the number one issue that occurs is maintenance, repair, and replacement of the HVAC system, and knowing who's going to be responsible for those repairs, let alone everything else in the space. Typically, the landlord's responsible for the exterior, tenant's responsible for the interior, but you really want to closely review who's responsible for what repairs and replacements in your space. Signage, you want to make sure that you understand where you can put your signage, whether that's if there's a monument sign out by the street. Is there like an index or a directory inside? Can you put signage above your door? Are you around the corner or in the back and you need to put directional signage out in the parking lot or on the exterior of the building? Do you want to put signage in your windows? All of these will be addressed in your lease. And my opinion is you have the most negotiating leverage before you sign your lease. If you're a franchise, then the franchise is going to have a signed package that the franchisor is going to want the landlord to approve prior to the lease being signed. And I generally recommend the same, even if you're not a franchise. If you're an independent business, you should have an idea of what kind of signage you're going to want to put in where. Does your landlord only allow generic signage, colors and size of letters? They don't allow you to put your logo up on the building. So you want to look to see what kind of signage you can put up. And then restrictions and covenants. So say you're an independent coffee shop, do you want to put a restriction in the lease that the landlord cannot rent to any other coffee shops, or businesses that generate more than 50% revenue from the sale of coffee or baked goods or burritos or whatever it is? There's enough competition out there in the industry and in the neighborhood. Do you really want another competitor right next to you in the strip mall? Generally, landlords won't do that because it doesn't make sense for their tenant mix, and why have two competitors within such a close proximity? But if the landlord needs a tenant, they're going to take any tenant, and then maybe the landlord will say, "Hey, let the strongest survive." But you can request a landlord to put restrictions in on who the landlord can rent to. And then you also want to check to make sure that there aren't any, that the landlord has not previously agreed to any restrictions on new businesses that can come in. And then a personal guarantee. So we talked about creating a limited liability company and a corporation to limit or minimize your personal liability. But ultimately, banks, landlords, may request that you give a personal guarantee to enter into this lease or to get a loan or something like that, which that's a different analysis, because even though it's a personal guarantee, now you're personally liable. This is a contract you're signing, and you can choose not to sign the contract, but the landlord may not lease to you if you don't give this personal guarantee. But this is a contractual obligation, and so it's up to you if you want to create this exposure, because maybe you're like, well, landlord A is requiring a personal guarantee, and that's a great space. Landlord B is not requiring a personal guarantee. It's a little bit off the beaten track. So are you willing to be a little bit off, the main thoroughfare, but you don't have to have a personal guarantee. You don't have to have that liability. And then if a landlord does request a personal guarantee, there's some ways to try to minimize it. Maybe it's only there for the first term, and upon renewal, it goes away because you're no longer a credit risk. If the landlord's willing to lease to you for another term, then they should be satisfied. But so there's some things you could try to work on there. But always be careful of those personal guarantees. Okay, next slide, please. General contract issues. The biggest is know what you're signing. Sounds basic, but if you don't understand every provision in a contract, that means you need to contact an attorney to have them help you review that so you understand the different provisions. because ignorance is not going to be a defense. That hey, I didn't realize that's what it meant, or I didn't even understand it. Because as in the next bullet point says, each paragraph has a purpose. You're basically in your contract, you're trying to apportion liability, in the future. No one knows what's going to happen in the future, but if these certain things happen, this is how we're going to address it. So just because you think this huge contract is a great paperweight or a doorstop, each provision and paragraph is there for a reason. And so you want to make sure you understand what all of those paragraphs means and the implication of those. It could be a form selection clause. So you're like, well, what's that? Like, oh, that's the clause that says if there's any dispute between the parties, all disputes will be handled in the state of Washington. And you're like, wow, that's inconvenient. And that's one reason why they do it. The other party does it is because it is inconvenient to go across the country to file a lawsuit. But if you're dealing with someone large, they may say, like Walmart, they're like, hey, we're not going to allow all these vendors to sue us all around the country. We want to have one court in Arkansas, hear and handle all our issues because we want one interpretation of our contract. So there is a purpose behind it, but you just need to understand if you do business with people outside the state of Ohio and outside the country, very difficult to easily get some sort of satisfaction if you have to file a lawsuit, especially if someone's outside the country and if there's just a minimal savings. I don't know if the benefit is worth it from a liability standpoint if you're not satisfied to try to get a resolution from someone outside the country and if someone's over in the adjoining county. And again, allocation of risk, who's going to be responsible if something occurs. And one of the biggest, issues are the next two bullet points is the statement of work and the compensation. What kind of work are you doing? How are you going to do the work? When are you going to do the work? What kind of quality is the work going to be in? Are you giving warranties on how long this, the service or the product you provide will last? And being very clear on that. And then the compensation, when are you going to get paid? Are there going to be break points where you get paid a little bit as the project progresses, or are you going to wait for 100% to be paid at the end? And if the customer is not happy, well, now you're going to be trying to collect the whole 100%. So I'm a big fan of, especially on large projects, could even just be building a website. The customer generally has no idea what they want, and then when they say what they want, but when they get what they wanted, they're unhappy with it. Because they just experienced someone else's website. So I'm a big fan of having various breakpoints where the vendor provides the service. Some point the vendor provides it to the customer to approve. Upon approval, then that customer pays for that, and then the next set of work is done. Because if something does need to change, it's a lot easier to change it in small increments rather than the whole entire item having to be redone. And plus, why as the business provider would you want to do a month or 3 weeks or 5 weeks or 6 weeks of work and not get paid at all until 6 weeks? Why let the customer keep that money for cash flow purposes? And then your boilerplate provisions. If you read enough contracts, you will find that there's a handful of provisions at the end of every contract that are relatively similar. Could be like an entire agreement clause that says, hey, if we negotiated it back and forth, we have a ton of emails, then we finally, came to this one agreement. The entire agreement clause may say, hey, anything that didn't make it into this contract, the parties did not agree upon. Because no one wants to look back and say, hey, remember we agreed to this in the email 6 weeks ago, but it's not in that contract. It should have been, you're supposed to do X, Y, or Z. And you're like, nope, if it didn't make it into the contract, not part of our agreement. So there's a lot of provisions about, those, they're kind of generic in general, but, you need to understand them to understand exactly, what kind of limitations or what types of terms you're agreeing to. Okay, next slide, please. All right, intellectual property issues. We're just going to quickly go through these, your non-disclosures, your patents, copyrights, trademarks, and licenses. Okay, next slide, please. So with your non-disclosure issues, you have non-disclosure agreements, non-compete agreements, non-solicitation agreements. So your non-disclosure agreement would be similar to a confidentiality provision or agreement that you'd have with your employees, contractors, vendors. I think it's very important that if you're going to be sharing, proprietary information, that be provided and agreed upon. Your non-solicitation and non-compete we had a brief discussion of non-competes earlier. We'll get a little bit more clarity in the near future whether these are still going to be enforceable or not nationwide. But even if non-compete provisions are not enforceable, not properly tailored non-solicitation provisions are. So a non-compete basically says if you ever leave, you can't do this type of work in with another employer or on your own. You're basically telling someone they can't earn a living with what they're good at. Where a non-solicitation provision is, you can go out and compete with me, you can earn a living, just don't steal my customers that I introduced you to. And so as long as those non-solicitation provisions are properly tailored, those are still enforceable, even if non-compete provisions are not. Okay, next slide. Patents, based on federal law, no state can issue a patent. Patents are filed with the U.S. Patent and Trademark Office, protects inventions and discoveries. The filing fee for a patent is not very high, but any legal fee from a patent attorney to assist you, could be anywhere from a few $1,000s up to over 10,000, depending on the complexity of your invention. So my opinion is, if you believe you have the next, best idea, and you're going to be wading into a space, large companies that are also competitors. Those large companies have attorneys on staff that are patent attorneys. They have inventors on staff. And if there ultimately isn't a new patent filed that is directly in their space, then they're going to try to find a way out around it. And that's where I think the patent attorney earns their stripes, is that they're the ones that have the knowledge and experience on how to write the claims to make sure you have as great a protection as possible. So if you really do think that you have one of the best ideas around and, it's going to put other big companies out of business, you better make sure it's properly drafted. And there's patent attorneys around. There's also, I believe Case Western, I believe Akron U, they have patent panels or patent clinics where they assist clients with their patent processing. So there are alternatives if you don't have the financial capital to go hire a private patent attorney. But I always recommend looking into that. Okay, next slide. Copyrights, and then the next slide, which we won't go to yet, are trademarks. People get those kind of confused. A copyright is a work of authorship of some sort. So think of music, think of lyrics, think of a painting, a book. Those are items that are able to be obtain a copyright for, and those are from the U.S. Library of Congress issues those copyrights. And those copyrights are good for the life of the creator, and then for a period of time after. And after that time period, the work goes into the public domain. And some of these historical cartoon characters that you grew up with are now going into the public domain. I think one of the most recent ones was Winnie the Pooh. Okay, next slide. And then trademarks. This is, I think, what most people think of. A trademark is a symbol, a word, a phrase, a logo. But the biggest thing is it's a source identifier. When you see that label or that name, you automatically know who made it. Potentially, if it's going to be expensive, exclusive, cheap, and it also provides what type of cachet goes with that name. So think of the Golden Arches. As soon as you see that M, it came from McDonald's. You see that the Starbucks logo or the name, it obviously came from Starbucks. Or you see a swoosh and it's Nike. You automatically think of some sort of quality that associates with that product or that service. So you said, so if you have a huge design on your shirt and it takes up the whole shirt, that's probably more of a copyright rather than a trademark. Because to be a source identifier, usually it's a small symbol on the chest of your shirt, maybe on a hang tag, maybe on the product itself. But some, if it's the entire shirt, that may be considered to be ornamental, and it's not a source identifier. It's more of a design. And then to complicate things even more, you can file a trademark with the U.S. Patent and Trademark Office. Then you'd get nationwide protection. You'll go through a pretty rigorous examination to make sure your name or your mark is able to be trademarked. And then, if you're in Ohio and you're like, I'm never going to go outside of Ohio, I don't care what anyone else does outside of Ohio. You can file a trademark application with your House Secretary of State. Very basic process and very little examination that's done. And your trademark will be good here just within the borders of Ohio. But if someone has a nationwide trademark that predates your trademark, that nationwide trademark will preempt you. So you do have to do some checking to make sure that your trademark will actually be available. So you want to do that clearance search. And then how are you going to name everything? Do you want the name of your company to be the same as the name on a website, the name on a social media account, and things like that? You want to check out some of these other, are you okay with abbreviations or adding of Ohio or of Cleveland or something like that to a website or a social media account to be able to use the name that you want to use? In general, I found that you have to make up words to be able to get a federal trademark. You almost have to make up words. Almost all common words seem like they've already been taken. I've had clients spell their name backwards to be able to get a registerable trademark. And then, and if you use common words like the fruit stand, generally, if you're selling fruit on the side of the road, you cannot get a trademark in the fruit stand because it's generic and it's descriptive. But if you use the fruit stand in a different way, like for a line of clothing, then that would be fine. But you can't stop people from using the word fruit stand if they're actually selling fruit on the side of the road. No different than Apple, right? I mean, Apple you can't use the word Apple or something similar if they're going to have electronic, type equipment. But if you're actually selling, plates and cups and, clothing that have apples on it and you call your product Apple, it's going to be difficult to keep you from, using that name since it's descriptive of what you're actually selling. So you have to be careful when you use common words because people can still use those for their common use. All right, next slide. And then licensing, we'll just quickly go through this. So if you ever do want to lease any of your intellectual property, then you will want to have a license agreement between you and the person that you're licensing the intellectual property to. And if you're going to be using someone else's intellectual property, you want to know how you can use it. What can you use it on? What types of products? Is it exclusive versus a non-exclusive license? Is it for a particular geographic area? What type of quality control will there be to make sure that the name is not used for or in conjunction with substandard product or services? So you do want to, if you ever are going to let someone else use your name or your products or processes or anything like that, you do want to make sure you have a license agreement in place. Okay, I believe that's the last slide. And if anyone has any questions, I'm happy to answer any of those if possible. And I don't ask for super specific questions that are just going to be applicable to your individual situation that don't have potential general applicability because I don't know if that's the best use of everyone's time. But if they're general questions, I'm always happy to try to address those. And also I give you, I applaud you, you all for wanting to be part of this program. SCORE volunteers are great, and it's nice to have a sounding board to talk to because when you're an entrepreneur like myself, when I sit down in a room, it's just me. I don't have anyone else to speak with or run ideas off of or try to get best practices done. So, and then I see a couple of questions here. Looks like they have to do with the filing, the beneficial ownership interest filing. So, is a sole proprietor required to file? If you are truly a sole proprietorship and you did not create your business by filing any paperwork with the House Secretary of State, so then the answer is no. But a lot of times people think they're a sole proprietor when they're the only owner of a company. So if you filed, so the other question is, will a single member limited liability company need to complete the forms? And the answer is yes. Doesn't matter how many owners you have. The fact that one of the main determining questions is, did you create your company by filing a document with the Secretary of State? And if that answer is yes, then yes, you have to file. So even if you have one owner of your company, shareholder or member, then yes, you do have to file. But there are exemptions for nonprofits. And I don't have any nonprofit clients, so I have not researched the nonprofit exemptions, but I know that there are some exemptions for nonprofit filing. And for people that are wondering, the CTA is the Corporate Transparency Act. With your House Secretary of State, is it a trademark or a trade name? So if it's going to be, Corpus Law Inc., which is my business, Chris's Landscape, that would be a trade name. That Chris's Landscape would be a trade name. So so a trade, the same word, the same name that you use, could have multiple, categorizations. It could be a trademark and it could be a trade name. So it all depends on how you use it. Remember that trademark is a source identifier. So your trade name could also be a trademark depending on how you use it. So it all kind of depends on use. But a trade name, and there's also a difference between a trade name and a fictitious name. A fictitious name is generally used with franchisees. When you file for a fictitious name, you are saying, I don't have exclusive right to use this name, but I want to use it. I want to let everyone know I'm using it. Where a trade name is, I do expect that I want to have, exclusive use in the state of Ohio using this name. And, ultimately, should you ultimately also trademark your trade name? Again, depending on how you use it, but there's no harm in also trademarking your trade name, again, depending on how you use it. So, a lot of times, there's another question here between, should I pick between an LLC and a corporation? I also recommend, every time you create your company, you should talk to your accountant and ask about taxation. Because the accountant may have an idea whether you should be a limited liability company or a corporation, or at some point in time, start off as a limited liability company and then, be taxed as a sole proprietorship and then move on once your income reaches a certain level and make the sub S tax election. So ultimately, it's really, I always think it's important to have your accountant come in because every business decision you make is going to have some accounting aspect. But if it was me and I was starting up a business and all things being equal, I'd probably create a limited liability company rather than a corporation. It's a very flexible entity. And then there's a question, would I use the form mentioned to copyright a book for $35? Yeah, you would go on. I mean, that's one of the areas that I recommend clients to attempt to do first on their own is obtain a copyright. The website is a very good website, very instructional. Just sometimes some people consider it to be easy to use. So yes, you would, go through and don't quote me on the $35. I have not checked to see if that's still the amount to submit a copyright in the last little bit. So,
Gary, we're up at the top of the hour here.
Yep.
And although there are more questions going, we do promise to people I've run just the last slide here. So I'm just going to share my screen briefly and bring up that presentation that we had that I did not have the slides going, and I apologize for that. And now you can see the how to whoops, there it goes. Oops, there we go. This is how you can request a mentor. Go to score.org, take a picture of that with your camera, or you can take a picture on the right to request a mentor. The web links are down below. You will get a copy of the the presentation. And just to round that out, it's www.score.org or www.score.org/find-mentor/request-mentor. And with that, I'm going to stop sharing. Gary, thank you very much for a great presentation. And we will get the slides and a link to the recording out to you in about a week's time. And with that, we're going to close at the top of the hour. Gary, again, thank you very much. Thank you, everybody, for joining us today.
Yeah, if anyone has any questions, my contact information is on the PowerPoint. You're always happy to give a call, and I give, potential clients a free half-hour consultation. So if anyone has any questions, just holler.
His name is Chris Corpus, Corpus, and you can find him on the internet if nothing else.